Joining us now to talk about the trial and its impact, civil rights lawyer, former prosecutor, David Henderson is with us this morning. David, good to see you again, sir. Thanks for your time.
My pleasure. Good to see you, Craig.
You know, let's talk about the enormity of the trial. I mean, this is one of those cases, one of the few that I can recall where just about everyone in this country knows about the case. They've seen the video. How could that affect the jury?
It's hard to say how it'll affect the jury beyond what the jury has already told us. The enormity of this case is impossible to overstate. This case will change policing in America. I think these jurors know that. What you also hope they know is the ability to have a positive impact through this case. Nobody gets healed in court, but the groundwork for healing can be laid in court. You hope that's true for George Floyd's family, for the people of Minneapolis, and for our country, because we all have something riding on the outcome of this case.
You have the unique perspective of having been on both sides, prosecutor and the defender. Who's better situated, David, right now, based on the evidence as we know it?
I'll break that down based on what I've seen from jury selection and the starting point for this trial. You have to give a leg up to the prosecution because they managed to pick a jury that's more diverse than the county that they picked the jury in, which is saying a lot. At the same time, in terms of strategy, I think the defense has a better feel for it going into this trial. Prosecution wants to keep things simple. Look, folks, what you see is what you get, and it's all on the video. It's the defense job to make things as confusing as possible to try to give the jury reason to find reasonable doubt. They've done a decent job of doing that so far.
What makes it so difficult, typically, David, to prove that a police officer or any member of law enforcement, for that matter, is guilty of murder?
You've got two things that make it difficult. One, juries, like the rest of us, are self-interested. We all want to think that police officers are out there keeping us safe, and that if something went wrong, there must be a really good reason for it. It couldn't be that they committed murder of someone during the course of an arrest. Jurors want to believe that. At the same time, when you're convicting a police officer of murder, you're typically trying to convict them of an unintentional murder, which is also always hard to get a conviction on. So in a case like this, you've got a double whammy, which makes it duly difficult to get a conviction. My
understanding, David, you correct me if I'm wrong here, that in the state of Minnesota, the prosecution doesn't necessarily have to prove that the officer's knee on Floyd's neck, that was the sole cause of his murder. They only have to prove that that was the major contributing factor to his death. Is that accurate?
That's basically accurate, but there's a bigger problem here, Craig, that you can't forget. The way you and I talk about the law outside the courtroom is different than the way the law is perceived by jurors inside the courtroom. When we're talking about the law at the high level in terms of technically what you have to prove, that's different than how a jury is going to make its choice. Juries make their choices based on who they trust, who they believe, and what feels right, more so than what the law specifically allows for.
David Henderson, enjoyed your insight, enjoyed your analysis, sir. Thank you. Thank you so much for being with us this morning.
Thank you.
Hey, thanks for watching our YouTube channel. Find your favorite recipes, celebrity interviews, uplifting stories, shop our favorite deals, and so much more with the Today app. Download it now.